And at the time that you handled Mr. Weldon's case, about how many criminal felony jury trials had you worked on?
Had I worked on, how many trials had I conducted?
How many felony jury trials have you conducted at that time?
I would say at that time probably close to 100.
Okay. And about how many appeals would you have handled at that time?
Probably an equal amount, not the same cases, but probably at least 100 appeals also.
Okay, thank you. And how did you come to represent Mr. Weldon on appeal in this case?
I received a call from the presiding judge, which was Judge Karen E. Byers here in the Superior Court of Gwinnett County. She asked me if I would take the case. I am on the appointed list in Gwinnett County. We do not have a public defender's office. We have an appointed system. I'm on the appointed list for appellate purposes only. So I took the case at the presiding judge's request.
Okay, and what did you do to prepare for petitioner's case?
His case was not really any different than any other appellate case I've handled. I guess I do it by practice and by rote. First thing I do is go to the, or once I'm retained, I go to the clerk of court. I ask to see their file and I copy it front to back, every document that's in it. It's free if I'm appointed, so I ask for every single document that's in the file. If there are any transcripts that I need to obtain, maybe hearings that have transpired that I don't have the transcripts for that aren't in the file, I request those. I contact trial counsel. In this case, I think it was Mark Pilgrim, I believe, if I remember correctly. Contact trial counsel and request their file. I go through it with a fine-tooth comb also. Basically, I'm looking for, I want to make sure I've got everything that trial counsel has generated and also everything that the district attorney has turned over to trial counsel in discovery. So I cross-reference certificates of service with what trial counsel gives me. And once I've got the clerk's file and once I've got trial counsel's file, I kind of start looking at it to see what this case is all about. If the trial transcript is ready, of course, I get that, but usually that's somewhere down the road. So that's the third part of the case as far as I guess my research and my investigation of the case is get the trial transcript, read everything in context with everything else, talk to the defendant, talk to the prosecuting attorney. I've got a pretty good relationship with the DA's office, most of them anyway, and talk to the district attorney about the case, try to get a sense of what has happened, talk to trial counsel again. I should have looked, but I think it was Mr. Pilgrim. I know him well. We talked about the case and just try to get a sense of what's going on, talk to Mr. Weldon, and eventually try to boil down what I think are the salient issues to present first to the trial court and then, if necessary, to the appellate courts.
Thank you. And so do you recall in this case that you raised 2 enumerations on direct appeal?
On direct appeal, I think I raised sufficiency of the evidence and the issue of that eventually went up on cert, the issue of I'll call it the shock belt. Okay,
so you actually ended up petitioning for cert and getting that cert after that on this case, correct?
That's correct. The case was by opinion in the Court of Appeals. I thought the very good issue was the issue of the shock belt and how it was placed upon Mr. Weldon without a whole lot of hearing or procedure. The Supreme Court initially agreed with me and said, yeah, that's a pretty good issue. But I think Justice Namias disagreed with me at some point in time. So it did go up on cert, and I did argue that, but it was the cert petition was granted, but the trial court was affirmed eventually.
Okay, and so I wanted to just turn to the grounds of the petition that Mr. Weldon has alleged. So I just want to ask first, have you raised ineffective assistance of trial counsel on previous appeals?
Have I raised it on previous appeals?
Yes,
Yes,
sir.
ma'am, many times. Many times. Often that's all you have.
Okay, so in this
I
case,
have, to,
was it a,
I have no qualms about raising ineffective assistance.
so in this case, did you strategically decide that there was no meritorious grounds of ineffective assistance of trial counsel in this case?
May I look at my amended motion for new trial and see exactly what I raised on the issue of motion for new trial?
Yes, sir.
I see that I raised certain issues on the motion for new trial, but my practice is generally to raise not as much as I can, but really I don't want to leave anything left on the table to present to the trial court. I want to give the trial court every reason to go. So I think I did raise ineffective assistance on the motion for new trial, but not on appeal because I have to make a value judgment then that I want to raise the strongest issues, and I don't like to cloud my good issues, what I believe to be my good issues, with issues that really carry no substance and no weight. It draws away from what I think is what I think the appellate court might like.
Okay, so you raised the issues that you believe would be most likely to succeed on direct appeal. Is that a correct statement?
That is correct.
Okay. So turning first to petitioner's first ground, he alleges that you should have raised ineffective assistance of trial counsel for trial counsel's failure to object to testimony of witnesses outside of Gwinnett County. Do you understand what he might mean by that, or know what that might be referring to?
I saw that allegation. I'm sorry. I've thought about it every way I can. I don't really understand what that is, and I can't really add anything to that. I'm sorry. I do not understand it.
Okay. If it were to refer to the similar transactions, did you investigate the similar transactions that were raised in this case?
I raised those issues, I believe, as part of the motion for new trial. So I did investigate the alleged similar transactions. Yes.
Okay. And was there a reason you did not pursue them on direct appeal?
I remember this case pretty well. And I'm not trying to be flippant. I wouldn't call them just similar transactions. I would call them eerily similar transactions. So, I mean, while I might allege, anytime the trial court has to rule on a substantive issues like this, I'm gonna look at it closely, especially in a case like this with so much at stake. So, I raised those issues, but in retrospect, Judge Byers, I think she ruled correctly in allowing those to come in.
Okay, thank you. And that was sort of his second ground as well. So I want to turn to his third ground, in which petitioner alleged that he received that you performed deficiently by failing to raise a claim of trial counsel ineffectiveness for trial counsel's failure to move for a continuance to investigate the charges and evidence in Rockdale County. Do you understand what he might be referring to on that enumeration?
I don't. That does not ring a bell. I don't see that I raised anything, and I've got a copy of my amended motion for new trial. I don't see I raised anything along that line here, so that really doesn't resonate in any way with me. I'm sorry.
Okay. And do you recall petitioner asking for a continuance prior to trial or anything like that?
I'm sorry, I don't recall that.
Okay, thank you. So I just want to summarize. Do you feel that you did the most that you could possibly for petitioner on direct appeal in terms of petitioning for cert and everything like that?
I wish I could have done more, but because first on the ground that I took to the Supreme Court, I think I presented the Supreme Court ample opportunity to clarify the law in a very important matter. They chose not to, which I take things as they come. Do I think I did all I could? Yes, ma'am. I hope I did, and I believe I did.
And just to clarify for the record, the issue on the Supreme Court was the shock belt issue, correct?
It was the issue of what it boiled down to what procedures the trial court must undertake and what considerations the trial court has to have in mind when they place someone in the shock belt, so that's what that was. So it was. I thought it was a good issue, and got to argue in front of the Supreme Court, but all for naught.
Well, thank you. That's the only questions I have for this witness at this time, Your Honor.
Mr. Weldon,
thank you, ma'am.
Cross-examination for this witness. Mr. Weldon, can you hear me?
You need to be on mute. Can you hear now?
Yeah.
Yes, sir.
Any questions for Step on cross?
Yeah. On the ground where she said about, because I don't have, I told you I have my DeKalb case, so I didn't bring, I brought the wrong folder. I brought all my stuff about my DeKalb case. But the ground referring to the continuing about the similar transactions. You said that you didn't recall anything about the similar transactions, but that's what both of my cases are all about, the similar transactions. The witnesses come from Gwinnett County to testify in DeKalb County, Gwinnett County to testify. So question is, how can you not stand referring to?
If I understand your question, Mr. Weldon, I'm going to beg to differ. I didn't say I don't recall anything about the similar transactions. I did not say that. Now, but his say was that I raised those issues as part of the motion for new trial. If you've got that in your file here or wherever, you'll see that. I did raise those issues, so I was aware of those issues. I just didn't think the issues were important enough to take up on appeal because, well, I just didn't. I thought the judge ruled correctly. So it's not that I don't recall it. I do recall it. I want the record to be clear in that regard.
Okay, well, yeah. See, I'm not referring. I'm referring to the witnesses that came from Gwinnett County to DeKalb County to Gwinnett County. I'm not referring. The similar transaction is what made the witnesses come from one county to another county. That's what gave them the authority to come. They were victims in DeKalb.
Your Honor, sorry, I'm going to object. He's testifying at this point, not asking a question.
Well, Your Honor, I'm just trying to establish a fact because on the first question, when she asked him about the first round, was did he know anything about the witnesses coming from Gwinnett County to DeKalb County? He said he doesn't remember.
I understand that. At this point, you're going to have to ask. I'm going to give you the opportunity to tell me anything you want to tell me at the appropriate time, both and verbally. But at this point, if you have questions for Mr. Stepp, you need to ask them. Other than that, this is not the time to make any statements.
Okay, well, that'll be all then, sir.
Okay, all right. So that we're going to end this hearing. Thank you, Mr. Stepp, for cooperating with us and providing your testimony here. And that will hopefully avoid having to join us in the future. Maybe even in Tattnall County. All right.
Judge, I appreciate the court's. I appreciate the court's consideration. Do I understand I'm excused?
You are. Thank you, sir.
Thank you, Judge.
Unless there's questions on redirect, I didn't ask Ms. Rosenmusser.
No further questions, Your Honor, for this hearing.
All right. Thank you, Mr. Stepp. Ready to go. And with that, we're going to.
Thank you.
Yes, sir. We're going to conclude this hearing for today, and we'll pick it back up when it's rescheduled. All right, thank you, Mr. Weldon.
Judge Stewart, I think your next date is May.
Yeah, I was
Is that
thinking
right?
March
May
was a little
26th?
quick, but they'll let him know.
Okay.
He's not going anywhere.
Right.
Okay, he's got time
He'll
on
be
his
there.
side.
Yeah, his,
He'll be here.
his calendar's been cleared. All right, so who do we have up next? Start at the top.
Yes, the only other request was that the Seoul Jordan State Prison case number 14 on the calendar be done last. They have some other hearings there that they're doing. So
Okay.
that's, but other than that,
All right, let's go to the Rawlson.
Excuse me, Your Honor, I have a question.
Roslyn,
Yes.
Your Honor, did I hear correctly that the Robinson case would be going last?
Eddie Robinson, yes, apparently that's a request from the facility. They've got hearings going.
Your Honor, if I may say something, GSP has joined the line with Mr. Robinson.
Okay, so we're ready to, he's available.
Okay.
He's not available just yet, Judge. He's coming down.
You want to handle that now?
He's not available just yet,
Okay, all right,
but we are on the call.
thank you, I appreciate that.
Okay.
You're welcome.
If you can let us know, we're going to go on with another hearing, but if you'll let us know when Mr. Robinson is available,
Yes, sir.
we're ready to go. Thank you. All right, so the next case will be Robert Rollison versus Brian Adams.
Yes.
Civil action 2018 HC 6.
Turn the video on to get there.
We have our Smith.
Yes.
Well,
Okay. I'll be over in 15 minutes if it gets on in there. Please.
Mr. Cravey, we can hear your conversation.
Sorry. Sorry about that.
all right, Mr. Rollison.
yes, sir.
All right, good morning, Mr. Rollison. Again, I'm going to ask everyone. We're going to mute everyone that's not speaking, but please speak one at a time. Mr. Rollison, are you ready to proceed?
Yes, sir.
Court calls the case of Robert Rollison as petitioner versus Brian Adams as respondent, civil action number 2018 HC 66. And is this Mr. Lindemann's case?
Yes, Your Honor, that's correct.
Okay, are you ready to proceed, sir?
Yes, Your Honor, we are ready to proceed, although I do believe the court had already discussed the issue of Mr. Grube's testimony, and that Mr. Grube will be coming back at a later date to testify, and that we were taking the testimony today of Mr. Cravey.
Okay, well, I wasn't aware of that. That's fine if we need to do it that way.
Judge, his whole office has COVID.
Oh, it's a
And-
COVID issue?
Yes, sir.
Okay.
Yes, Your Honor.
Sorry.
All right, so Mr. Rollison, do you understand what Mr. Lindemann is saying? Apparently there's a witness who's unavailable because of COVID. So we'll take all the testimony that we can today, and then we'll come back in the future and take that witness's testimony once he's cleared quarantine and available to testify. All right, so with that, what I'm gonna do, Mr. Rollison, is ask Mr. Lindemann to give a brief outline of the allegations that you've raised in your petition. You have understood.
I believe that Mr. Rollison has subpoenaed both witnesses.
Okay, they're under his subpoena. All right. All right, so I'm going to allow Mr. Lindeman to call the witnesses, conduct direct examination of those witnesses, and at the conclusion of direct examination, I'll allow cross-examination by Mr. Rollison of those witnesses. Are you willing to proceed in this manner, Mr. Rollison?
You say that I do the direct examination and that he crosses?
No, I'm going to allow Mr. Lindeman to call those witnesses, and he's going to conduct a direct examination, and then I'm going to give you the opportunity to cross-examine his witnesses. And then I'll allow you to call any witnesses that you have under subpoena.
Well, I apologize. All the witnesses in this case are under his subpoena, or under petitioner's subpoena.
Right. So the petitioner doesn't have any witnesses.
Correct.
So with that, Mr. Lindeman, if you would just give me an outline of the allegations raised in the
Mr. Rollison is challenging his November 2014 Pulaski County guilty plea conviction for malice murder, for which he received a life sentence. The grounds that Mr. Rollison had raised in his initial petition had changed once he eventually moved over to an amended petition. And in the amended petition, ground one, petitioner has raised, he alleges that the indictment was defective and void in that Pulaski County, an elected official from Pulaski County, was the foreperson. He alleges that the indictment was not returned in open court, and that count one did not allege an essential element of the case, and that the indictment did not allege a code section violation. Ground two, petitioner alleges that the court did not have subject matter jurisdiction and or legal authority to pass judgment on his materially defective indictment. And then ground three, petitioner alleges that he received ineffective assistance of guilty plea counsel when guilty plea counsel failed to challenge the validity and sufficiency of the indictment, knowing that there were material defects in the indictment. And I just wanted to double check, are those the three grounds that Mr. Rollison is planning to move forward with?
Can you confirm that for us, Mr. Rollison? All right, somebody needs to unmute there at Smith State Prison. We can't hear Mr. Rollison.
Go ahead.
Is that better?
Yes.
Okay, the amended grounds of the petition, ground one was correct, ground two was correct. Ground three, there's two instances of deficient performance, and that is counsel failed to enforce a ruling on the general demurs, and that counsel failed to ensure that the guilty plea was voluntarily, knowing, and intelligently entered. There's also ground four, and that is that I, the petitioner's guilty plea, was not entered voluntarily, knowingly, and intelligently. These were amended on January 7th, 2021.
Is that the brief? In the brief, is that correct?
Yeah, that is also in the amended brief as well.
Okay. Yes, Your Honor. That's correct. We have those as well.
Okay. All right. Anything further? Rollison, call this person.
Did you say to call the first witness?
I'd ask Mr. Lindeman if there's anything further from the counsel for the respondent. I'll allow Mr. Rollison to call his first witness.
I apologize, Your Honor. That is all from us, from the respondent, Your Honor.
All right, Mr. Rollison, you may call your witness.
All right, I'd like to call Henry Cravey to the stand.
All right, Mr. Cravey, are you with us?
Yes, sir.
All right. Good morning, sir. How are you?
You need to enable this now.
Mr. Cravey, I need you to use your camera so we can see you.
Okay. You got it?
There you are.
Okay. Yes, sir.
If you would raise your right hand to be sworn, please, sir. The testimony you're about to give to be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may proceed, Mr. Rollison.
Will you please state your full name for the record?
Henry Earl Cravey III.
So that's Henry Earl Cravey III. What do you usually go
Just Henry Cravey.
by? Okay. Mr. Cravey, do you know who I am?
I know your name. I don't remember you. I vaguely remember you when you was renting a house. You and your mother was renting a house for me on 25 Lumpkin Street.
Okay. So you do know my mother, Dina?
Yes, like I say, it's been what 10 or 12 years since y'all lived in that property. Yes, sir.
And so my mother and I lived in one of your rental units at 111 Lumpkin Street.
Correct. Yes, sir.
And were we your first tenants in that unit, if you remember?
I really don't remember. I think you were, but I don't remember really. I really don't.
Did you ever have to do any renovations on the house when you first purchased it?
All right, Mr. Rollins.
Yes, sir. I did. Yes, sir.
Before we go any further, Mr. Rollins, let me point out that habeas is not an opportunity to retry your case.
Yes, sir.
Raise specific constitutional challenges to your conviction.
Yes, sir.
Process that you went through that resulted in you being incarcerated by the state of Georgia. I'm going to limit your questions on direct examination to those questions that may be relevant to the issues that you've raised in your.
Yes, sir.
You're not going to retry your case.
Yes, sir. These questions are relevant because it establishes the personal relationship between the witness and I. And also, I will establish the identity of the witness, which prejudiced my case.
Well, I'm going to give you a little leeway because I understand the pro se with, and you're not an attorney from, or if you are, I've not been made aware of that. But at the same time, I'm going to comply with the rules, and you are going to ask questions that are relevant to the issues raised in your petition.
Okay, yes, sir. Mr. Crazy, did you come over regularly to the house to do renovations on the house when my mother and I were living in the house?
I more than likely did. Yes, sir. Probably did. Yes, sir.
Okay, in addition to your real estate presence in Hawkinsville, what other ties to the city or the county do you have?
One of the city commissioners in Hawkinsville.
How long have you held public office in Hawkinsville or Pulaski County?
This year will be 17 years.
Okay. Well, I know that exact times and exact dates are hard for some people to remember. Is there any way that we can allow Exhibit 1A to be viewable by the witness?
I'm going to defer to my IT guy. What's the easiest way?
Maybe he filed some.
Mr. Rollins, is this an exhibit that you have previously filed with the court?
Yes, sir. Yes, sir. Exhibit 1A.
You got the camera over here?
It just got mailed to the clerks. We only have a hard copy.
Yeah.
All right, let's try to do that.
Who has it?
Bear with us just a second. We're going to put this on the camera. Hopefully
Yes.
it'll pop up on the screen and we all can see it at the same time. Mr. Lindeman, do you have any idea what 1A is?
I do not, Your Honor. That is, we did receive there was a large, about 200-page, request for documents that Mr. Rollison had put in. We did receive that. I don't have copies of any exhibits other than that.
I sent it to you today.
Exhibit 1A was a part of the original exhibits that I submitted back in 2018, early 2019.
I think it's about to pop up on the screen here. We've located it. So bear with us just a second.
Okay. All right, this is Exhibit 1.
Good there.
Excuse me.
Slow, but he's good.
Or not. He can have a
All right, unfortunately, Mr. Ross, it doesn't look like you actually marked your exhibits. Anyway, you didn't mark what was sent to the clerk's office. So what document are you specifically referring to? Let's see if we can do it that way.
Exhibit 1 is a certified copy from the city clerk of Hawkinsville, Diana Carney. It's a letter that shows elective offices that were held during the time of 2012 and 2013.
All right, let's see if we can locate that document.
It should be written at the bottom of Petitioner's Exhibit 1A.
But it's free. Case name.
No, I did not. Can you check there while I check here? So that way. You see it? Okay. Okay.
It was the brief he found right.
Okay, what document number?
County, I guess it's all.
It is 2018.
There it is. All right. Mr. Craven,
Yes, sir.
did you serve as chairman of the Board of Commissioners in 2012?
I don't remember. I don't remember that far back. I sure don't. But if it says it, I did. Yes.
And in 2013, you were a regular member of the board?
Yes, sir.
And in 2013, were you a regular member of the Board of Commissioners?
I was. Yes, sir.
Were you elected into these offices by vote?
Yes, sir.
Were you elected into these offices by popular vote?
Yes, sir.
And Mr. Craven, did you serve as foreman on a grand jury in 2013?
I was. Yes, sir.
There's one more document that I'd like to show the witness, and it's right above this one. It's Exhibit 1. Now, on page 1 of Exhibit 1, is that your name signed as foreperson in the middle of the page?
Yes, sir.
Did you yourself sign your name?
It looks like I did. Yes, sir.
Well, does that look like your handwriting and the words "true" above your name?
Yes, sir.
And down below at the date, you filled in the date June 24th, 2013, correct?
Correct. Yes, sir.
Mr. Craig, after you signed this document, do you remember what happened next after it left your hands?
No, sir, I do not.
Okay. And were you elected as foreperson by the members of the body of the grand jury, or were you appointed by the court?
I was elected by for there. Yes, sir.
By the body?
Yes, sir.
So when you served as foreperson on this grand jury, you were currently a member of the Board of Commissioners, correct?
I was. Yes, sir.
No further questions, Your Honor.
All right. Any cross-examination, Mr. Lindeman?
Just a couple questions, Your Honor. Mr. Cravey, good morning.
Good morning.
Did you believe that your position as an elected official had any bearing on your duties as a foreperson?
No, sir.
Did you feel that you were able to fulfill your duties as a foreperson impartially and correctly?
Yes, sir.
No further questions, Your Honor.
All right. Any other questions, Mr. Ross?
Mr. Craig, did you know service as foreperson on this grand jury was illegal?
No, sir. I didn't know that. No, sir.
You didn't feel that our past history, our relationship with each other would have affected your ability to determine these proceedings fairly, did you?
Objection, Your Honor. That's been asked and answered.
I'll sustain the objection. Any other questions?
No, sir, Your Honor.
All right. Thank you, Mr. Cravey. You're welcome to remain with us, or you're free to go.
Thank you, sir.
Thank you. Call your next witness, Mr. Ross.
Mr. Grube is the only next witness that I have, and apparently he's not available today.
Okay. All right. So at this time, I would presume we would conclude, unless Mr. Lindeman, anything else we can take up from the respondents?
Well, Your Honor, for exhibits, would you like me to tender those at the next hearing so that it's all together?
Yeah, let's wait until the next hearing.
Okay.
It's that time. Mr. Rollison, that concludes the hearing for today's purposes. You'll be notified when we will be back to take up the testimony, and hopefully the witness will be with us at that time. Anything else perhaps, Mr. Rollison?
Well, at the next hearing, will I allowed to do an opening argument and closing, things like that?
Absolutely.
Okay.
All right. Thank you, sir. That concludes the hearing.
Message from witness in item 8, Mr. Benjamin's case has a hearing in another court at 10:45 to know you would go ahead and hear that.
Call that next.
Yes, sir.
Okay.
Which case was that? I apologize.
Baruch Binyamin.
Your Honor, so
Baruch Binyamin.
Hold on just a minute.
I may be.
Your Honor.
Yes, sir.
Your Honor, I spoke with his attorney yesterday. His attorney was supposed to be on this morning. His attorney was going to continue this because he actually filed he attempted to file an amended pleading yesterday and didn't realize that Tatnall does not do electronic filings. And he wanted to give us time to respond to that. Again, it was supposed to be on this morning at 8:30 so that we could discuss this with you pre-hearing, but he was also, it's his witness, so he was also going to let the witness know as well. And that's the Baruch Binyamin case.
Good morning. This is Vernon Smith. I apologize. For some reason, my video is not working.
Sorry. Okay. Here.
This was a case we had actually in lieu of the several grounds that my client had originally filed when I got on the case. After going through the case, we had one ground. I've sent it to Your Honor as well. I believe you have it by email. I also sent it to the AAG. But it is a situation. I've been trying to get a verification by Mr. Benjamin. I have sent this twice to the prison, and he has not received it either time. I haven't been able to speak with him since last week. I've tried a couple of times, but there's been some events that had happened at the prison, and they were unable to allow him to speak with me. Basically, I'm just trying to get him to verify. I understand that Mr. Lindeman has an issue with trying to get this done, and I certainly agree with him that he does need time to reply to this. And I believe that we had both decided that a continuance on this might be appropriate. I have talked with my witness on the case, Mr. Daniel. He was supposed to be on today anyway, but I don't see him on here. It might be a situation. Oh, there he is. And I know that he wanted to kind of go forward on his own, so he wouldn't have to come back. I think that it's probably not going to take a terribly long time for his testimony to be given.
Any objection to handling it that way, Mr. Lindeman, or would you prefer that we just come at a later date and do it all?
To be completely honest, Your Honor, I have not had a chance to go through the ground, and so I don't know if I'm prepared to go through with his testimony, considering that the ground, we just found out about the ground yesterday, to go through all the transcripts and everything as well. So.
With that, we're gonna continue the Benjamin case. And I think, is it May, my next,
May 26th.
calendar?
That's right.
There's 4 judges in this circuit. We met, Mr. Lindeman's aware of this, Ms. Rosenwasser's aware of this, but, my next habeas calendar won't be until May, so I'm sure this case will be on that calendar.
Mm-hmm.
So this, all right, is this Mr. Benjamin?
No, do you want Mr. Benjamin in?
No. That's not him. No, that's not him. That's fine.
Good morning, sir.
Good morning. How are you? Who is this at Georgia State Prison that just came in?
Robinson.
Okay, and we'll take him up next. As to the Benjamin case, we're going to continue that until my May calendar. All right, that concludes that issue.
Thank you, Your Honor. I apologize, Mr. Daniel, for making you come back. But
I'm not driving down there. Have a good day.
exactly.
Your Honor, can y'all tell me who I need to bring in next?
Mr. Robinson, I think is Mr. Robinson may be at GSP.
Oh, we'll get Mario.
Next.
Maybe no.
Yeah, okay. The next case we're going to take up is the Robinson case, but at Smith State Prison, Stallworth will be next. Oh, you give Stallworth. That's okay. Is this Mr. Robinson?
Yes, sir.
Good morning, sir. How are you?
Good morning, sir.
Ask everyone else in microphones, because we're getting a lot of background noise. Mr. Robinson, we're going to call your case next. If at any time during this hearing you have a different hearing what's being said, please let me know. I want to back up and make sure that you have the ability to hear all the testimony, all the questions, anything that's said in your habeas proceeding, okay?
Yeah, yes, sir. You're going in and out. I hear you, but you're going in and out a little bit.
Okay. I'm doing the best I can.
Yes, sir. Yes, sir.
All right. Court calls the case of Eddie B. Robinson versus Travanza Bobbitt. It's 2020 HC 30, Superior Court of Tappan County. First of all, Mr. Robinson, are you ready to proceed this morning?
I mean, the best I have, Your Honor, I wrote when I filed my Hague, you know, I'm just not learning this myself. You know, I'm not familiar really with court, and this is new to me. So I'm just doing this the best I am. And when I sent it in to the clerk, I told her, you know, my grounds, but I also just let her know just straight up, you know, my comprehension and level is kind of a little bit lower. You know, I just got my GED right here in prison. I just got it, and I got the thing right here just to show you real fast. You see this right here?
Yes, sir.
I just got my GED, and they gave me a Hope. They gave me a Hope GED voucher. So I'm doing something positive with my time, and you know, I'm taking like other academics, like these are other certificates, things that I'm trying to accomplish, trying to better myself. But as far as the law, I'm trying to read it the best I can. So I have this right here, the amended complaint, and I'm just trying to do it the best I can. And like I told her on one of the grounds, I have a 6-year-old son, and I'm just trying to get home to be a father to my son and do this thing the best way I know how, sir.
Okay. All right, let me respond to that, Mr. Robinson. I understand what you're saying, but this habeas is a civil proceeding, and the law doesn't allow me to appoint counsel to assist you. So you're gonna, unless you can afford to hire an attorney to represent you, most petitioners in a habeas case are in fact pro se. So it's not unusual for someone to be in the situation that you're in, and I respect that. I'll give you a little bit of leeway, but just a couple of ground rules. First of all, this isn't an opportunity to retry your case. So you've alleged some constitutional violations that occurred during the process that resulted in you being incarcerated. So I'm going to limit the testimony to questions that are relevant to the issues that you've raised in your petition. Okay?
Yes, sir.
All right. Now, procedurally, this morning, what I'm going to ask is Mr. Lindeman is the attorney representing the respondent, Ms. Bobbitt, or Mr. Bobbitt. I'm going to allow him to give me an outline of the allegations that you've raised in your petition. Mr. Lindeman, do you have any witnesses?
Sir?
I can't hear you, Mr. Lindeman. You're going to need to...
Yes, Your Honor, we have one witness.
One witness? All right, Mr. Robinson, do you have any witnesses that you intend to call this morning?
Somebody like the people that came to the court for me. You can call them, yes, sir.
No. Okay, so you don't have any witnesses subpoenaed for this hearing this morning, is my question.
Oh, no, sir. That's what I ain't been able to get in touch. This coronavirus, I ain't been able to get in touch with nobody. But like to have the same person, Corey Lowe, the club promoter, he actually came and testified at the motion for new trial. I would like to have him. But like I said, I have to have a way to communicate with him and things like that. And by this coronavirus, we're locked down. It's hard in here.
I understand. All right, so what I'm going to do is I'm going to allow Mr. Lindeman to call the witness that he has and conduct a direct examination of that witness. And at the conclusion of the direct examination, I'll allow you to conduct a cross-examination. You can ask him any questions you want to ask. All right? Are you willing to proceed in this matter, Mr. Robinson? All right, with that, Mr. Lindeman, if you want to give me a brief outline of the allegations that were raised in the...
Sure. So Mr. Robinson is challenging his 2018 DeKalb County jury trial convictions for rape, attempted kidnapping, and 2 counts of those convictions were affirmed on appeal in Robinson v. State. That's number A19A0712, and that was from the Georgia Court of Appeals, unpublished, and the decision came down June 12, 2019. For the enumerations on appeal, petitioner alleged that the court erred in refusing to allow him to proceed pro se without a Feretta hearing, ineffective assistance of counsel when trial counsel failed to interview material witnesses, the trial court error in denying a motion to sever charges, and that the court also sua sponte determined that the evidence was sufficient. In terms of the claims for his habeas petition, Number one, the indictment was improper because the grand jury proceedings were not in open court or properly entered on the minutes. Ground number two, petitioner's right to confront his accuser, Tone Smith, was violated. Ground number three, ineffective assistance of trial counsel for failure to impeach victim Cameron Page. And then Mr. Robinson also filed an amended petition with further grounds, with additional grounds. Number one was ineffective assistance of trial counsel for failure to object to character evidence, the confrontation issue that they failed to object to, and also the state's use of bolstered testimony. Ground number two in the amended petition, petitioner's right to confront the criminal attempt charges victim was violated, again, a confrontation clause issue. Ground number three, petitioner's due process rights were violated when petitioner was denied a pretrial hearing on his refusal to testify. The state did not present victim testimony as to one of the charges. The trial court did not exercise discretion on the record during sentencing, and the trial court used illegally obtained criminal convictions to enhance petitioner's sentence. Ground number four, the state allegedly put petitioner's character on trial. Ground number five, the state illegally bolstered the rape victim's testimony. Amended ground six, the witness for petitioner refused permission to give evidence of petitioner's innocence. Ground number seven, petitioner received an illegal sentence where the trial court did not use discretion in exercising its discretion on the court for petitioner's sentence, and that it was illegally obtained convictions, and that those were used to enhance petitioner's sentence. Number eight, in the amended grounds, IAC, ineffective assistance of counsel for appellate's counsel failure to investigate the claims that petitioner raises in this habeas corpus petition. And ground number nine, ineffective assistance of trial counsel for failure to impeach evidence against another victim, Cameron Page, again. So those are the grounds that we have so far in the amended petition and the original petition. And then again, Your Honor, we have one witness that we would call.
All right, you may call your witness at this time.
All right, I believe Mr. Begnot on the line.
Some people waiting, but I don't know who it is. You would warn us who it is.
It's Mark Begnot or Begnot.
Mark Begnot.
Begnot. There we go. Let's see. And, all right. Okay.
If you would raise your right hand and be sworn, please, sir. You swear affirm the testimony you're about to give to be the truth, whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you, sir. Good morning.
Can you please state your name and profession for the record?
No, sorry. Mark Begno. I'm an attorney.
Okay. And what year were you admitted to the Georgia Bar?
2008.
And since becoming a member of the bar, how have you been employed?
As an attorney.
Okay. And is that in private practice or is that in with the government?
I have my own firm now. I've also worked for the government.
Okay. At the time, where were you working? At the time that you represented petitioner?
I was working from not with my current firm, but I was working with my previous firm, but in private practice.
Okay. And at that time that you were representing a petitioner, what % of your practice was devoted to criminal work?
It varied over the 5 years of the life of that firm, between a third and a half.
Okay. And of that time, or of those, how much of that was felony trials?
Felony trials. I think when I was with that firm, I did 2 or 3 felony trials.
Okay. And what about guilty pleas?
Probably 30 or 40.
Okay. And have you handled appeals as well?
Yes.
Okay. And any idea at that time roughly how many appeals you had handled?
Including federal, probably in the ballpark of 20.
Okay. In regard to the representation of petitioner, can you explain a little bit how you came to represent petitioner?
It was appointed. I had a contract with the Georgia Public Defender Standards Council. It was GPD-SC at the time. And so I was paid by the state to represent as appointed counsel.
Okay. And at what point in the proceedings were you appointed?
After he lost at trial.
Okay. Did you only do the direct appeal, or did you also do the motion for new trial as well?
I did the motion for new trial, the direct appeal to the Court of Appeals, and the cert petition to the Supreme Court.
Okay. Did you have any contact in that time with the trial attorney?
Yes, a little. I mean, I called her to testify. We raised ineffective assistance of counsel against her. I had at least one phone call previously, and I also had her file.
Okay. And what issues do you recall did you raise on appeal?
I remember the primary two. I can recall four. I think I raised four, at least in briefing. The primary issue that I raised on appeal was a FREDA issue, that Mr. Robinson had unequivocally invoked the right to represent himself, which was denied without hearing by the trial court. I also raised ineffective assistance against trial counsel. And I raised a severance issue. I believed that the two separate incidents should have been severed. And I asked, at least at the motion for new trial, I asked the trial court to exercise its power as the 13th juror.
Okay. And do you recall the issue that you raised with the ineffective assistance of counsel?
It was the failure to call witness Corey Lowe, who would have provided impeachment evidence against one of the two alleged victims.
Okay. And do you see any other meritorious or viable issues in the proceedings that you did not raise?
I mean, honestly, I don't remember. I know that there were other issues that I talked about with my client, but I mean, to know which ones I went through and the reasons that I raised or the reasons that I didn't raise other issues would, I mean, I can't sitting here tell you exactly why I did or didn't raise something.
Is it fair to say that had there been a meritorious or viable issue, it would have been something that you would have put into the brief or raised with the appellate court?
Yes, I mean, I hope so. If there was something that was meritorious and viable that I didn't raise, it would mean that I missed it.
Okay. Now going a bit to some of the specific allegations in this particular habeas petition. The petitioner raises quite a few things with ineffective assistance of trial counsel. And again, you had mentioned that that was something that you had raised in the brief. Were there any other issues that you noticed of trial counsel's ineffectiveness besides the one that you raised in the brief?
I remember there were some dodgy decisions that she made during trial, but I don't recall seeing any of them as being maybe weighty enough to raise at the motion for new trial hearing. Like I definitely remember one incident while she was cross-examining one of the witnesses where I think Judge Scott cleared the courtroom and chastised her for how she was actually examining the witness. And so it didn't strike me as being particularly great practice, but I don't know that I saw that as something that would have gotten us a reversal.
Gotcha. Okay. And let's see. I think that's all the questions that I have, Your Honor.
All right, Mr. Robinson, do you have any questions you want to ask the witness?
I'm just trying to get some help, like best way I know, sir. Just trying to get, and justice. Just trying to get justice in the court, Judge.
I understand, and you're not required to ask questions at this time, but if you would like to ask questions, now is your opportunity to do that.
Yes, sir. Like I say, I'm just trying to comprehend. I don't even know. Like I said, I'm having someone kind of aid and assist me with this, sir. I'm just trying to see how could I help, what I can do. Like I don't have an attorney. I don't know the law, and I'm just trying to do this the best way I can, Your Honor.
Okay, and I appreciate that. I understand what you're saying. So I take it that you don't wish to ask questions of Mr. Is it Benyay?
Heck no.
No, I didn't have it right. I wasn't close either time. Sorry.
No worries.
Oh, I mean, all I can say is Mr. Mark right there. How you doing, Mr. Mark?
Hey, Mr. Robinson.
He's a good lawyer. He contacted me, wrote me back and forth. He tried to help me the best he could. He let me know the next stage. I had to do it on my own. And this is the stage I'm doing it now, but every other stage he was there and he did his best, trying to help me get this life sentence back so I can get home to be a father to my son.
Okay. All right. I'm going to release Mr. Benyay from the subpoena. Thank you, sir, for joining us.
Thank you, Judge.
Any other witnesses?
None from the respondent, Your Honor.
Okay. All right. And Mr. Robinson, you indicated that you don't wish to call any witnesses or don't have any under subpoena at this time. Anything else you want to tell me?
I'm just trying to see like what stage, or I mean, like what do I need to do now? Like I just need to know what do I need to do so I can be trying to put the work in, so I can try to give some of this time back, sir.
Okay, what I'm gonna do is go through the record in your case. Are there exhibits, Mr. Lindeman, that the respondent has for this case?
Yes, Your Honor, we have 3 exhibits that we were going to tender today, and then we were also going to ask if we could leave the record open for, the Court of Appeals still has not sent over the on appeal and the transcript as well. We're still waiting on, but what we do have today is the Court of Appeals opinion, and then the briefs in the Court of Appeals as well from the appellant and the appellee.
Okay, all right. So you want to tender the exhibits that you have for today?
Yes, and am I able to share my screen so I can show them?
Sure you can.
Is that...
And just so for Mr. Robinson's benefit, sir, and based on what you've told me about being unfamiliar with our proceeding, the exhibits that are going to be tendered by Mr. Lindeman on behalf of the respondent make up the record in your case, both from trial and we're going to hold it open so we can get the records in from the Court of Appeals. What you have raised constitutional challenges in your habeas petition, so we're going to go through the record, research the record, to see if what you have raised in your petition gives rise to a constitutional violation that would allow the court to enter an order that grants your habeas petition or not. But the only way that we're able to do that is by going through the record that, in your case, both the trial record and the appellate record. So the exhibits that Mr. Lindeman has available this morning constitute the records from your trial. And I'm going to allow the record to remain open so he can supplement those exhibits with the records from the Court of Appeals. Okay, and I'm just telling you that so you'll understand procedurally what we're doing here this morning. Okay.
Yes, sir.
All right. With that, Mr. Lindeman, if you want to tender your exhibit.
Okay. Can y'all see the screen?
Yes.
Yes, sir.
Okay. So this is Respondent's Exhibit 3, and this is, again, the unpublished opinion in the Georgia Court of Appeals in Robinson v. State. That's A19A0712. Respondent's Exhibit 4 is the appellant's brief in the same case. And Respondent's Exhibit 5 is the appellee's brief in Robinson v. State. And again, Respondent's Exhibit 1 is going to be the record on appeal, and Respondent's Exhibit 2, when we receive those, will be the entire trial transcript as well.
Any objection, Mr. Robinson, to any of these exhibits that are being tendered?
When you saying like what am I supposed to say? I'm supposed to ask something or something?
No, sir. I'm just asking if you have any objection to the court allowing these exhibits to be entered in the record.
Oh, I get it. I mean,
Quite frankly, it's kind of hard for me to make a decision if I don't have these exhibits available to me so I can look back at the history of your case.
Oh, yes, sir. Yes, sir. You can look at it, Judge.
All right.
Your Honor. Your Honor.
Sir. All right. So these exhibits are admitted without objection. All right. Anything further?
That's all from the respondent, Your Honor.
And we're going to hold this open as far as tendering exhibits for the Court of Appeals record after it's made available.
Correct, the record and the transcript. And those will be the only additional exhibits that we have.
Okay. And once we receive that, Mr. Robinson, the court will consider the record and I'll get an order out to you. Okay?
And Your Honor, is there any way you can get this? He can give you, like, I got a copy of these right here. Is there any way he can get copies, or do you like statements, like the things that I have, like police report, like how it's meant, like I didn't pay the girl, and how she did make statements like, and that's how this whole thing started out, just because I didn't pay her the money. Like, is there any way you can see all that stuff?
If it's a police report, it's possible that it's in the, contained in the exhibits that have already been tendered.
Yes, sir.
Yeah, it would likely be in the Court of Appeals record, I would guess, Your Honor.
Right, so if it's been.
It's in the regular trial transcript, and the regular police reports, like how they was asking her questions. They was like, ma'am, why are you with this dude at 4 or 5 o'clock in the morning? And she was like, oh, because he's going to pay me $400. And you know, because we've been out, I'm a club promoter, but then I didn't have the money, I didn't pay her the $400. And that's what this whole thing is about, because I didn't pay her the money, Judge.
It sounds like that's the kind of thing that would be in the record from the trial of the case if that was a defense. And so, yes, and that goes back to what I was explaining to you earlier about submitting these exhibits. It's going to allow me to have access to those types of records so we can look at the allegations that you've raised in your petition. All right?
Yes, sir.
All right, thank you, sir. That concludes the hearing.
One quick question, Your Honor. Where would you like us to send the exhibits? We have them in electronic version, so we can email them.
Did you say where or when?
Sorry, to which email address? Because we have them in electronic versions, so I figured that would be easier than mailing them.
Right. If you could send them to my habeas clerk.
Okay.
Ms. Worthington?
He's got that email.
And you have that email address, I believe.
Yes, that I do.
Okay. All right, that concludes the hearing.
So what do I do now, Judge? Like, you just gonna get back with me, or?
Yes, sir. You'll get an order.
All right, thank you, Your Honor.
All right, thank you. Good luck to you.
Good, yes, sir.
And this is Mr. Stallworth at Smith, is that right?
Yes, sir.
Good morning, Mr. Stallworth.
Good morning, sir.
Get your file. This is case number 2008, Stewart, Tattnall County, Michael Stallworth versus Terrence.
I didn't hear you, sir.
I'm sorry?
I didn't hear you, Your Honor.
Okay, can you hear me now?
Yes, sir.
All I did was call the case, Michael Stallworth versus Terrence Kilpatrick, case number 2019 HC 49. And I want to verify that you are in fact Michael Stallworth, is that right?
Yes, sir.
Okay, are you ready to proceed here this morning?
Yes, sir.
All right, and Mr. Lindeman, apparently you're handling this on behalf of respondent?
Yes, that's correct, Your Honor.
And are you ready to proceed?
Yes, Your Honor.
All right, Mr. Lindeman, if you would, please give me a brief outline of the allegations that are contained in this petition.
Sure. Your Honor, Petitioner Stallworth is challenging 2012 Fulton County jury trial convictions for malice murder, 2 counts of felony murder, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony. And that was affirmed on appeal in Stallworth v. State 304 GA 333 2018. Mr. Stallworth filed this petition on August 1st, 2019, and this is currently the second setting of this case. The first one was May 20th of 2020. However, that was reset due to COVID. And then the only claim that we have here is that the crime scene proved petitioner's innocence due to exculpatory evidence. And we don't have any witnesses. We just have documents to tender, assuming that is the only ground that Mr. Stallworth intends to go forward with.
All right. And Mr. Stallworth, is that the only ground that we are proceeding on here today?
Yes, sir.
Okay. Do you have any witnesses subpoenaed?
No, sir.
Stallworth, okay. All right. I'm going to give you an opportunity to testify or tell me anything you want to tell me if you in fact do want to testify.
Yes, sir. I would like to say something.
All right, raise your right hand and be sworn. You swear affirm the testimony you're about to give to be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
Right. If you would state your name for the record.
Michael Dwayne Stallworth.
Mr. Stallworth, you're the petitioner in the case that I previously called Michael Stallworth versus Terrence Kilpatrick. which is a habeas petition, case number 2019 HC 49, Superior Court of Tappan County. Is that right, sir?
Yes, sir.
Okay, you may proceed to tell. You understand that you're subject to cross-examination by Mr. Lindeman?
Sir?
You understand that I'm going to give Mr. Lindeman an opportunity to ask you questions on cross-examination if he desires to ask you any questions.
Yes, sir.
All right, you may proceed.
Your Honor, first thing, good morning.
Morning.
I'm not going to waste your time this morning. I have with me transcripts that I would like to present that proves that the jury came up with their own theory about the crime scene. Testimony that they came up with their own theory about the crime scene. I understand that this proceeding is all about the violation of constitutional rights, so I don't want to waste your time this morning. I just would like to present these transcripts to you so you can look over and actually see for yourself the proof that the jury, as testified by my trial attorney, that they did come up with their own theory, did not follow the judge's instruction, but came up with their own theory about the crime scene.
Okay, and I would assume that the exhibits that Mr. Lindeman is going to tender at the conclusion of this hearing will include the transcripts that you're referring to. Is that right, Mr. Lindeman?
Yes, Your Honor. We will be tendering the transcripts for the trial and for the motion for new trial as well.
Okay.
But, excuse me, Your Honor, may I speak?
You may.
The particular transcripts I have is from an October the 8th, 2015 jury misconduct hearing. So I would like to ask the question, do you have those on file as well?
That is not something that we have in our transcripts. Again, our transcripts are strictly from the trial and the motion for new trial hearing as well.
Okay. Any objection to leaving discovery open or leaving, not discovery open, I've been in the civil world too long. Any objection to allowing the petitioner an opportunity to submit, of course, he's going to have to provide a copy to counsel for the respondent. But if there's a transcript of a misconduct hearing regarding jury misconduct, any objection to allowing him to supplement the record with that in the future?
I would only ask that we reserve the right to object at some point once we've had a chance to actually go through the transcript and look at it. Subject to that, if that's okay, then we would not be opposed to him submitting that.
Okay, so what I'm going to ask you to do, Mr. Stallworth, if you can provide a copy of that to Mr. Lindeman at the Attorney General's office.
Yes, sir.
And provide a copy of that to the court.
Yes, sir.
I'll give Mr. Lindeman an opportunity to respond to the transcript once he receives it.
Okay.
And after that, we'll either reschedule this to give him an opportunity to go on the record as to his objection. If he has no objection, I'll consider the exhibit and get an order out to you based on my review of the application of the law to the evidence. Okay?
Yes, sir.
All right. Thank you, sir. That's going to conclude the hearing if there's not anything else we need to take up.
Again, Your Honor, I apologize, Your Honor. Did you want us to tender our exhibits, or did you want us to wait as well?
Sorry, I do need to give you an opportunity to tender your exhibits. If you'll hold on just a minute, Mr. Stallworth.
Let's see. All right, I'm going to share my screen again to run through the exhibits that we were going to tender. Respondents, let's see. And okay. Respondents is going to be the clerk's record from the Georgia Court of, or excuse me, from the Georgia Supreme Court. Respondents Exhibit 2 is going to be the transcript from the jury trial and again from the motion for new trial hearing as well. And then Respondents Exhibit 3, let's see if I can. Respondents Exhibit 3 is the brief of appellant in Stallworth v. State in the Supreme Court of Georgia. Respondents Exhibit 4 is the brief of the appellee from the district attorney in the same case. And Respondents Exhibit 5 is the appellant's brief from the attorney general in that same case in the Georgia Supreme Court. And those will be what we plan to tender.
Any objection to any of these exhibits?
No, sir.
Okay, so they're admitted without objection. And I'll leave the record open 60 days to give Mr. Stallworth an opportunity.
No, sir, no objection.
All right. So I'm going to leave the record open 60 days to give Mr. Stallworth an opportunity to all right. That concludes your to Mr. Stallworth.
Thank you, sir.
Damian Simpkins.
Your Honor, I'll be representing respondent for that case.
Good morning, Your Honor. Elizabeth Brandenburg for Mr. Simpkins.
All right, good morning. Are you Mr. Simpkins? Have we got his mic? I think he's muted.
Yeah, I can't unmute him.
All right, could I ask the staff there at Smith to unmute Mr. Simpkins for just a second, please?
Okay, I'm sorry.
That's fine. Thank you, ma'am. I appreciate the help. Are you Mr. Damian Simpkins?
Yes, sir.
All right, good morning, sir. We're here for, I'm going to call the case of Damian Simpkins versus Terrence Kilpatrick, case number 2019 HC 52. It appears Mr. Simpkins is represented by Ms. Brandenburg.
Yes, Your Honor.
Good morning.
Good morning.
Are you ready to speak?
Yes, we are.
All right, and Ms. Rosenwasser is here on behalf of the respondent, is that correct?
Yes, Your Honor, and I'm wondering if Smith could mute Mr. Simpkins if he's being represented by Ms. Brandenburg today, just to cut down on the feedback.
Yeah, listen, okay, I think they just did that, so. All right, Ms. Brandenburg, you may proceed.
Thank you, Your Honor. We've raised one issue in this case, that appellate counsel was ineffective in failing to properly present an argument on appeal that was deemed abandoned by the Supreme Court for not being providing proper citation of authority or argument in appellant's brief. We have one witness that I believe the respondent has called as well, Andrew Fleischman. We're ready to proceed.
All right, Mr. Fleischman.
Transfer him over.
Okay, he's being transferred in by our law clerk / IT expert.
He's on. He just needs to.
All right, Mr. Fleischman, if you could speak so we could activate your audio.
Hello, Your Honor. I'm here.
There he is.
Can y'all hear that?
Yes, we did. Good morning. Can you turn your camera on as well so we can?
I am trying. I'm saying unlock my video for me. It's my first time using this. Let me, all right. Here we are. Some progress.
Not yet.
Here we are, Your Honor.
All right. Good morning. How are you?
A hard morning. All right. Hey, everybody.
This is like it's like Letterman or something. All right. Raise your right hand, sir. You swear upon the
All right.
testimony you're about to give, be the truth, whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
All right, thank you. Ms. Brandenburg, you may proceed.
Thank you, Your Honor. Mr. Fleischman, can you state and spell your name for the record, please?
Andrew Fleischman, AndrewFleischman.
Thank you. And Mr. Fleischman, how are you employed?
I'm an appellate attorney with Ross and Pine.
And how long have you been employed in that respect?
3.5 years with Ross and Pine.
How long have you been an attorney?
Since 2011.
And in what manner have you proceeded in your practice? Have you always been a criminal attorney?
Yeah, I started off interning at the Municipal Court of Atlanta. Then I went to work in private practice for Bubba Head's firm doing DUIs. Then I was a public defender in Paulding County, Central Appellate Public Defender in Atlanta, and finally working with Ross and Pine.
And do you recall representing?
I'm sorry to interrupt. Could Mr. Fleischman speak up? I'm really having an extremely hard time hearing him on my end.
Okay, one sec. Let me get a little closer here. And I'm sorry, my laptop is just not working great this morning.
I can hear you now.
Speaking up a little bit. All right. Let's try here.
Do you recall representing? Yeah, I can hear you. I've turned my volume up a little bit. Okay. Do you recall representing Mr. Simpkins? Oh, yeah. Yes, I can hear you. Can you hear us?
Okay. Yeah.
Do you recall representing Simpkins in this?
Yes, I do.
And how did that come about?
I was working with the Central Appellate Office. We were assigned about 40 to 45 cases. He was one of those cases.
So he was appointed? You were appointed to represent him?
Yeah, I was, as a public defender.
And how did you go about preparing the case for appeal?
I read the transcript, spoke to trial counsel, looked at the issues in the case. And when I did that, I identified really only one issue.
And what was that issue?
That issue was the Bruton problem. So in this case, a co-defendant, Mr. McRuder, had identified Mr. Simpkins as the shooter. At trial, he used a pronoun. They redacted his statement to use a pronoun to refer to him as someone, and there was no Bruton instruction. So I believe that this violated the holding of Bruton.
So what was your focus in, or what was the issue that you ultimately raised?
The issue that I ultimately raised was that using McRuder's testimony in this way violated the confrontation clause. Because the prosecutor in opening referred to McRuder naming Simpkins as the shooter, and in closing, and because there was no instruction to disregard that statement about McRuder, for McRuder, I believe that the jury quite reasonably could have held that McRuder was referring to Simpkins when he made those statements, and in fact had no instruction not to. And in fact, when the Supreme Court of Georgia was looking at sufficiency in this case, they used that evidence as part of its sufficiency to show that beyond a reasonable doubt, Mr. Simpkins had been convicted.
So would it be fair to say that you thought that the co-defendant's statement, McRuder's statement, warranted exclusion under Bruton?
Yes. Both because the pronoun definitely referred to somebody, which sort of violated that 1998 holding in Richardson v. Marsh, or sorry, Maryland. And also because there was really, in my view, no way a jury could have heard that statement and not think it was referring to Simpkins. This was, after all, a case where they were trying to convict Simpkins of being the shooter. And why would they do that if McRuder was referring to somebody else in these pronoun statements?
So what, is it fair to say that the issue in your mind was twofold, that the statement should be excluded, but also that a limiting instruction should have been given?
Yes, though they're sort of related, right? So if you look at Bruton, what Bruton says is if you give a proper instruction to the jury, an instruction that they cannot hold statements against the defendant, then we assume the jury is following that instruction so long as you make reasonable efforts to redact it, right? That's the rule in Bruton. So here, I believe the redaction was inadequate even if you had the instruction, but then there was no instruction for the jurors to follow. There was no reason to apply the presumption they would follow an instruction they were never given.
And under what posture did you raise that issue?
I raised it as ineffective assistance of counsel. And trial counsel said he believed there were no brutal problems with the case. He believed the redaction was adequate to not require an instruction.
And how did you present the issues on appeal?
On appeal, I raised it as one enumeration of error, saying that there was a brutal violation. And I tied all that stuff together into one big issue, right? I was saying, there was a brutal violation because of these two problems, the failure to do the instruction and the failure to properly redact it. But what the Supreme Court of Georgia found, and looking back, I can kind of see what they were saying, was that I didn't really specifically argue the failure of the instruction, right? I didn't say, hey, listen, y'all, you can't even apply this presumption unless you can show that they were given an instruction. I didn't make that argument until my motion for reconsideration.
So the court deemed that the argument about that the instruction should have been given was abandoned. Is that correct?
Yes, there is a footnote. There are two separate footnotes dealing with it. One said the issue was abandoned. The other issue said, hey, you don't even need the instruction if there's proper redaction.
And in that footnote, did the court also state that you had argued that the lack of instruction made the statement more violative of Bruton?
Yes, I believe that is what it said. I guess I didn't realize what an issue this was going to be until oral argument in the case, which may or may not be in the record. But, we were going up, I was arguing it, and Justice Namias was asking me, well, isn't it okay if they redact, even if you have no instruction? And I was like, no, that's not the case. And at that moment, I probably should have realized that my initial brief had not adequately addressed the issue. But I thought, well, no, I'd answered it at oral argument. It'll be fine. But no, I didn't sufficiently raise the issue for the court to see that you can't you can't redact without the instruction. Basically.
And after the argument, did you request leave to file a supplemental brief?
I believe I did file a supplemental brief after oral argument, but maybe I didn't. I'm trying to recall now. I filed a reply brief in the case. I guess I did not file a supplemental brief.
And you referred to a motion for reconsideration. Did you file that after the court filed its opinion in the case?
Yeah. So after the court filed its opinion in the case, I filed the motion for reconsideration, basically saying, hey, maybe I didn't raise this adequately, but if you look at the case law, you really can't do a redaction without instruction.
Did you intend the issue that even if the statement came in under Bruton and was sufficiently redacted, that a jury instruction should have been given?
Yeah, I was hoping to raise that issue.
That was your intention?
And it was my intent that was an issue that would be before the court.
Did you intend to abandon that argument?
No.
You didn't have any reason to have done that if that's what the court's conclusion was?
No, I mean, in fact, I applied for leave to petition for cert with the Supreme Court of the United States, and unfortunately they denied my request for a stay. But I really believed that this issue was an important part of the case, and that even looking at federal habeas opinions under the AEDPA, you could see courts routinely saying this is a really big deal when you don't give that instruction.
And when you filed that motion for reconsideration, you further elucidated and brought out the argument about the instruction. Is that correct?
Yeah, I mean, at that point, I really dug much deeper into the law than I had before, which kind of shows, where there was room for improvement. So I've showed cases from like the 7th and the 3rd circuits, all saying that any reasonable lawyer would know that you cannot redact somebody's statement without that instruction.
So did you cited cases in your motion for reconsideration had not cited appellant initial brief?
Absolutely. I mean, I believe wrongly, apparently, that the Supreme Court cases, Marsh and Gray, addressed this instruction presumption issue, but I really hit it hard on the MFR, went through all the cases in the federal jurisdictions that had held specifically that point. And then I also showed Melendez-Diaz, which is a 2009 case from the Supreme Court dealing with the Confrontation Clause, where Justice Scalia specifically said, hey, The only reason we ever said you can allow in these Bruton statements was because of the instruction.
Did so you cited Melendez-Diaz in your motion for reconsideration. Did you also cite Richardson v. Marsh in that motion for reconsideration? Had you cited Richardson v. Marsh in your initial brief?
I honestly don't remember. I'm guessing not. I probably went with Gray, with Maryland v. Gray, but.
Okay, and if you cited Maryland v. Gray, do you recall citing it for this proposition or for whether it was for another proposition?
No, I cited it for other propositions. I was saying that this redaction was inadequate. I cited all the cases that talked about the redaction being inadequate, but then I did not cite those cases for the specific proposition that you needed the instruction in order to do the redaction in the first place.
Okay. Thank you. I have nothing further at this time.
All right, cross-examination by Ms. Rosenwasser.
Thank you, Your Honor. Mr. Fleischman, so I just wanted to get for the record, how long have you been practicing in Georgia?
2011, since 2011.
Okay, and how much of your practice has consisted of criminal law?
Oh, 95%.
Okay, at the time that you handled petitioner's appeal, how many appeals had you done previously? I think your sound wasn't working.
Could you repeat that for me?
At the time you handled petitioner's appeal, how many previous appeals have you handled?
Oh, probably 30 or 40.
Okay. And had you done any felony jury trials at that time?
Yes.
About how many, ballpark?
First chair, just one. Second
Okay.
chair, 2 or 3.
Okay. So mostly appellate practice, is that correct?
Yeah.
Okay. Now, I wanted to just, I know we already discussed that issue. So basically, your biggest concern in this case was the Bruton situation. Would that be fair to say?
Yeah, that was the big issue in the case.
Okay. And in fact, however, in the opinion, the Georgia Supreme Court basically found that there was not a Bruton issue. Would that be fair to say as well?
What they found was that there was not a Bruton issue because they didn't need the instruction if they had the redaction.
Okay. So I'm looking, I don't know if you remember the exact footnotes, but I know you mentioned footnote 5 in your direct testimony, and that would be where the Supreme Court mentioned the Bruton instruction. Is that fair to say?
Yeah. So they specifically said that you don't need an instruction, that there's no harm in not giving an instruction if there's a redaction, and that I had failed to preserve and raise that issue.
That you had failed to preserve and show any instruction or authority for an instruction. Is that correct?
Right. They said that I presented no authority at all, and I completely waived the argument that you required an instruction to do a redaction.
Okay, but they overwhelmingly did say that there was not actually a Bruton violation. Is that correct? They determined there was no Bruton violation.
I don't know that they did it overwhelmingly, but what they said was that I provided no authority for my argument that you needed the instruction to get the redaction.
Right, but I'm also saying they did say that the statement was not violative of Bruton. Is that correct?
They said that the statement was not violative of Bruton. Well, no, what they said was that I had not raised that issue. I had not properly preserved the issue that it was improper, right?
They
said that I had not presented any authority that there was a problem with not doing
for the instruction.
Right.
But I'm asking in that opinion, they also said that these statements were not violative of Bruton. They determined that the statements were not a Bruton problem in the opinion. Is that correct?
No, I'm going to disagree with that. I think what they said was that the way I had raised it, there was no problem. But, they said there was no authority at all for the argument that the instruction was improper. So I don't know what they would have held if, for instance, I had properly raised the issue and said that the lack of an instruction was improper and had authority in argument.
Okay, so it would be your testimony that you feel that the Supreme Court actually did not make an opinion on the Bruton violation. Would that be correct in your testimony?
It's my opinion that they ruled that as presented it was wrong, but they didn't make a ruling that properly raised it would have failed.
Okay. That's all I have for this witness at this time.
Any redirect? I think you did, Ms. Brandon.
Yes. Thank you. Sorry. Briefly, Your Honor. Mr. Fleischman, and you say that when you're talking about the holding in this case in the appellate opinion, did the court make a determination about whether or not the statement, the co-defendant's statement, should have been excluded?
Right. They made a statement that, as raised, I had not raised enough to exclude that statement.
So that's the Bruton violation that you raised, correct? That the statement should have been
that is the
excluded.
Bruton violation that I raised.
And let's go back a little bit about Bruton itself. What is your understanding of the law that pertained to co-defendant statements that existed before Bruton in the Supreme Court?
There was a holding that you had to give a clarifying instruction to juries that they could not hold a statement of a co-defendant against the defendant if you're going to introduce those statements. What Bruton did was it broadened that protection. It said it's not enough to give the instruction under some circumstances. If you make it too obvious the co-defendant is talking about the defendant, a jury is not going to be able to disregard that. So the initial holding was that you need an instruction, and then Bruton held you need the instruction plus some obfuscating.
Well, if Bruton excludes the statement, then the instruction is not necessary, correct?
If Bruton excludes the statement,
if the co-defendant statement does not come into evidence, then no instruction is required.
That's right. You keep the statement out, no instruction is required.
And then after Bruton, is that when Richardson v. Marsh came out about the, what's your understanding about Richardson v. Marsh and what happened after Bruton?
My understanding of Richardson v. Marsh, is that the 98 case? Or that's 98 is the gray. My understanding is that it said that you could, with sufficient redaction, allow it in with an instruction.
And so is it your understanding that either the statement is out under Bruton if it's too direct regarding the co-defendant statement, or if it comes in because it's sufficiently redacted, then an instruction is still required?
Yeah, so that would be basically my understanding. You either keep it out or you put it in with redaction and an instruction.
And you testified earlier, you're not sure that you included Richardson v. Marsh in your appellate brief. Is that correct?
I am not confident that I did in my initial brief.
And was it your intention to not include the law that would support that contention?
No, I was reading back over my brief, in preparation for this, and while I really wish I had said specifically, hey, you really need this instruction under Bruton and you can't do without it, I didn't make that specific statement. Instead, I made a sort of hand-wavy statement. I was like, hey, listen, without the instruction of the jury, of course we'd have held this against the defendant. But I did not clearly state that proposition of law.
Thank you. Nothing further.
Any further cross?
Just very briefly, Your Honor. Mr. Fleischman, I do just want to confirm, though, I know we went back and forth on this previously. In this particular case, would I be correct to say that the Supreme Court did say that they did not clearly find a Bruton violation? Is that correct?
They did not find a Bruton violation in this case as raised.
Thank you. I have no further questions for this witness at this time.
All right. Can Mr. Fleischman be released from his subpoena, or does he need to stay with us?
No, Your Honor. He can be released.
Yeah.
All right.
He can be released, Your Honor.
Have a good day, Mr. Fleischman. You're welcome to stay, but you're free to go. Call your next witness.
No other witnesses, Your Honor.
All right, Ms. Rosenwasser.
We have no other witnesses, Your Honor. However, I do have exhibits if I may enter those.
Okay.
Okay, and I'm going to try to share my screen here.
Have these exhibits previously been made available to Ms. Vandenberg or not?
I believe she was able to reach out to us, but we can show them to her via this split screen. They're just the trial court records and the appellate records.
Okay.
Here we go. Let me know if this is.
Yes, we can see that.
Okay, can we all see it?
Yes, thank you, ma'am.
Okay.
Yes.
So this is Respondents Exhibit 1, which is the trial court record here. And this is the index to the record.
No objection, Your Honor.
All right, one
Okay.
minute.
Here we have Exhibit 2, which is the trial court record, like the entire record. The first one was the index to the record.
No objection.
Submitted.
Okay, here we have Exhibit 3. That is the preliminary hearing transcript.
No objection.
Here we have Exhibit 4, which is the motions transcript for April 30th of 2015.
No objection.
Submitted.
Here we have Exhibit 5, which is the first part 1 of the motions hearing for July 17th, 2015.
No objection.
Submitted.
Here we have Exhibit 6, which is the second part of the July 15th, 2015 motions hearing. It was a 2-part transcript.
No objection.
Submitted.
Exhibit 7, we have the exhibits that went to the July 17th, 2015 motions hearing. It's the transcript of the exhibits.
No objection.
Submitted.
For Exhibit 8, this is the motion for new trial transcript.
No objection.
Submitted.
Okay. Exhibit 9, this is the first part of the trial transcript. Part
No
1.
objection to all of the trial transcript.
Okay, that's Exhibit 9, Exhibit 10, Exhibit 11, Exhibit 12, Exhibit 13. I think I may have clicked off Exhibit 14. One moment, please. Here's Exhibit 14. This is all the trial transcripts, part 1 through 6.
No, that's 9 through 14, is that right?
Yes, Your Honor.
All right, any objection?
No objection.
All right, 9 through 14 are admitted.
Okay, Exhibit 15 is the appellant's brief to the Supreme Court of Georgia.
No objection.
Submitted.
Exhibit 16 is the Attorney General's brief to the Supreme Court of Georgia.
No objection.
Submitted.
Exhibit 17 is the appellant's reply brief filed to the Supreme Court of Georgia.
No objection.
Exhibit 18 is the appellant's motion for reconsideration that was filed with the Supreme Court of Georgia. This is the case where he raises Richardson v. Marsh as discussed in the testimony.
No objection.
18 is admitted.
Exhibit 19 is the denial of the motion for reconsideration.
No objection.
Submitted.
And Exhibit 20 is the motion to stay remitted filed by appellate counsel.
No objection.
Submitted.
And Exhibit 21 is the denial of the motion to stay remitted on this case with the Georgia Supreme Court.
No objection.
All right, submitted.
And I'm trying to unshare my screen now. All right. I think those are all the exhibits from the respondent, Your Honor.
All right, each of the exhibits has been admitted without objection. All right, anything else we need to take up?
And Your Honor, I would just like to briefly put on the record just a moment of just our position here is that the Supreme Court opinion in this is Simpkins versus State 303 Georgia 752. That's a 2018 case. And just our position here is that any issue with failing to have raising the limiting instruction issue, the court decided that, basically that it wouldn't have a change in the outcome because, as they said that the Bruton issue, that the statement itself was not Bruton. So of course the court can look into that further, but we did just want to put that on the record briefly.
All right. Thank you, Ms. Rosenwasser. Anything further, Ms. Brandenburg?
Just to respond briefly, Your Honor, our position is that Bruton, while the court may have found that Bruton itself wasn't violated, that only did not require the exclusion of the the co-defendant's statement that was redacted, that referred to Mr. Simpkins only in redacted form, but that under both Richardson v. Marsh and the law prior to Bruton, that the instruction would still have been required, and that it was ineffective assistance of counsel to have not requested it at trial. That issue was raised was attempted to be raised in the motion for new trial and appeal, but was abandoned by counsel when it was not properly supported, and that constituted ineffective assistance of appellate counsel.
All right. I'll consider the record and get an order out to you.
Your Honor, I have one other issue while I have the floor. I can still be seen and heard. Our office also represented Otis Williams, and I just want to make sure that he was taken off the calendar as he had been transferred.
Yes. He was number 15. Well, he's on my list, and we did get notification, so that's been continued.
Thank you, Your Honor.
And Your Honor, for the exhibits, would Your Honor like me to mail those or send those via email?
What's your preference?
Mail.
Mail?
Mail to Sandy.
Okay. If you would mail a hard copy, I think that'd be better.
And who do I mail them to and at what address?
She want me to email her my address?
That'll work.
Yeah.
My court reporter is going to email you her address, whether it's be mailed.
Okay, thank you so much, Your Honor.
Your Honor, may I have the opportunity to either present a brief on this matter or a proposed order for the court's consideration?
Absolutely. How much time do you need?
30 days.
All right. And Ms. Rosenwald, would you like to respond?
Yes, Your Honor, we'd like the opportunity to respond.
Okay. 14 days beyond the 30?
Okay, thank you, Your Honor.
All right, thank you. All right, Mr. Sanders, I'll take this under advisement. We'll review the record and get an order out to you, okay?
Thank you, Your Honor.
Thank you. That concludes the hearing. All right, let's go to Leonard Brandon.
And Your Honor, Kathleen McCandless from our office is going to be representing the respondent on this, so she's just going to take over my camera right now.
All right, would you say her last name again?
Here, she'll come give you all them. McCandless, and she can spell that for you. I don't want to misspell it.
Okay.
Right. I'm alternate speaking.
And Mr. Leonard.
You probably want to get your exhibits for me. So here's the little exhibit. Ground Division 3.
All right. Is this Mr. Brandon Leonard? Sir. All right, good morning. How are you, sir?
Good morning, sir. I'm fine. How are you?
I'm good. This is case number 2020 HC 27 versus Brian Adams. Mr. Leonard, are you ready to proceed this morning, this habeas hearing?
No, sir. I have a couple of pieces of evidence that I wasn't able to submit, and I need a little bit of time to get this evidence in.
All right, Ms. McCandless, what's your response to the motion for continuance from the petitioner?
Can you hear me, Your Honor?
I can. Thank you, ma'am.
Okay. We currently have a witness who's been waiting, so it would be great if she could testify today, but I'll leave it at your discretion.
Okay. Any objection, Mr. Leonard, since they do have a witness available, if we go ahead and take that testimony, I'll continue the balance of the hearing to give you the opportunity to obtain the items that you've indicated that you need to get to submit as evidence in the future. But that way, that witness wouldn't have to come back. We would preserve their testimony. Do you have any objection to that?
No, sir. No, sir.
All right. So with that, what I'm going to do is I'm going to ask Ms. McCandless, representing the respondent, to give a brief outline of the allegations that you've raised in your petition, and then I'll allow her to call the witness. And Mr. Leonard, I'll give you the opportunity to cross-examine this witness if you'd like as well. Okay?
Yes, sir.
Thank you, sir. All right, Mr. McCandless.
Okay. Petitioner is challenging his 2008 Fulton County convictions for a jury trial for 2 counts of malice murder, 2 counts of possession of a firearm during the commission of a felony, and these were affirmed on appeal in Leonard versus State number 292 GA 214 in 2012. And this was originally filed in Chattooga County, but it was transferred to Tatnall last year in April. And there are also currently 2 pending motions that were filed by petitioner. One is for a writ of peremptory mandamus, and the other was a motion for summary judgment. And respondent has filed a respondent opposition to both of those, and we sent our arguments made in those responses.
Okay. All right. Call your first witness.
Oh, can we also put the grounds on the record?
Yes, I'm sorry. I didn't mean to cut you off.
Petitioner first alleges that his 5th and 14th Amendment rights and the Georgia Constitution rights were violated when he was forced to defend against felony charges by the Superior Court of Fulton County without said court legally establishing subject matter jurisdiction because there are no records of the grand jury proceedings in the clerk's office to verify the indictment was returned as a true bill in open court. His second ground is that he alleges his 5th and 14th Amendment rights and his Georgia constitutional rights were violated when the Superior Court of Fulton County convicted petitioner without establishing legal subject matter jurisdiction because there are no records in the clerk's office to verify the indictment was ever returned in open court as a true bill. And his last ground, in ground 3, he alleges ineffective assistance of trial counsel and appellate counsel for failing to investigate and or challenge the validity of the illegal indictment in this complaint and failing to investigate the facts of this case in good faith and loyalty to petitioner.
All right, you may call your witnesses.
Respondent calls Barbara Collins.
All right. She available? Okay. Yeah, Ms. Collins, if you would say something so you would appear virtually.
Good morning. Good morning. Can you hear me?
I can. Good morning, Ms. Collins.
Yes.
You need to enable your camera as well. So we can
okay, I'll try. Oh, here we go. There, okay. Can you got me?
Yeah. Oh, just from a housekeeping measure as well, Mr. Leonard, I want you to listen to me. If at any time, and we're obviously doing this virtually, you're located at Smith State Prison. The witness, I'm not even sure where the witness is. Ms. Rosenwasser is in her office in Atlanta, I assume, or at her home in Atlanta. I'm in the town courtroom. So, Mr. Leonard, if at any time you experience any problem hearing anything that's said over the course of this hearing, please get my attention and we'll make sure we back up and clarify that for you, okay? All right, thank you, sir. Ms. Rosenwasser.
And for the record, Kathleen McCandless is going to be representing respondent for this and asking the witness questions.
Sorry, I apologize. I knew that.
That's fine.
All right.
Okay. Ms. Collins, could you please state your name for the record?
She needs to be sworn.
I think I need to be sworn, but yes.
Ms. Collins, raise your right hand to be sworn. You swear affirm the testimony you're about to get to be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you, ma'am. You may proceed.
Okay. Could you please state your name for the record?
My name is Barbara Moore Collins.
What year were you admitted to the Georgia bar?
1986.
And what are you currently doing today?
I am happily retired.
Okay. Could you give us a brief description of your job history?
From 1986 to 1989, I was employed with a private firm doing real estate transactions. In 1989, I was hired by the City of Atlanta Solicitor's Office, and I was with that office until 2008, at which time I retired from the city. But then I took a contract with, or several contracts with the Georgia Public Defenders Standards Council, representing conflict defender cases, and Mr. Leonard was one of those cases.
How much of your practice was dedicated to criminal law?
Well, obviously, I was a criminal prosecutor for almost 20 years. And then subsequent to that, I was doing criminal appeals from the defense standpoint.
How many felony jury trials had you handled at the time of petitioner's appeal?
None. I'm trying to think if I was with the municipal court. So we did, when I first started with the city, we did preliminary hearings on felony cases, which were then subsequently bound over to the county. And then Mr. Howard initiated his complaint room. And so our jurisdiction on preliminary hearings was ended. And we, at that, around that same time, we were combined with the City of Atlanta Traffic Court. So I can't recall if any of the traffic cases I handled were felonies. It's entirely possible, but I can't claim to have handled at the trial level any felony cases.
How many criminal appeals had you handled by the time of petitioner's appeal?
When I was working for the City of Atlanta, I was in charge of the appeals division for the city. So I handled dozens, if not scores, of criminal appeals on behalf of the city. After I left the city, I handled 10 cases for the Public Defender Standards Council. But those were all kind of simultaneously. So that's the best way I know to answer that.
And how were you brought into petitioner's case?
I was brought in under contract with the Public Defender Standards Council.
Okay. And at what were you brought in?
After he was convicted, I handled the motion for new trial, the appeal on the motion on the denial of the motion for new trial to the Supreme Court.
And how did you prepare for petitioner's case?
Well, I obtained the full record of the case, of course, reviewed that extensively, everything from the indictment to the transcripts to all of the records, the hearings that were, that were held. I also had extensive discussions with the public defender who handled Mr. Leonard's case at trial. And I do remember this case because Ms. Bea, who was the trial attorney, was really upset, I guess, by Mr. Leonard's conviction because she felt that he got a raw deal. And so she and I discussed all of the case and, possible issues that could be raised.
And turning to petitioner's allegations in this case, he makes multiple claims about his indictment. Did you see any issues with the indictment?
I did not. And that's, of course, one of the issues that the trial attorney also looks at very closely because, as we all know, issues that aren't raised at trial generally will not be heard on appeal. And so we did discuss the indictment, and it was the conclusion of myself as well as Ms. Bea that the indictment was sufficient.
And he also alleges that you did not investigate his case. Did you investigate his case and determine which issues would be the most meritorious?
Absolutely.
For any trial.
Absolutely. And in addition to my own investigation, I met with Mr. Leonard and discussed with him the issues that I had discovered, and specifically gave him an opportunity to identify any issues that he felt should be addressed. And he never mentioned the indictment, or my recollection is that he did not mention the indictment during those discussions.
And did you raise any of those issues at trial? I mean, at the motion for new trial?
Any of the indictment issues?
Well, did you raise all the most meritorious issues that you found?
I raised 5 issues on appeal that I felt had some merit. And so, yes, I raised every issue that I could find that I felt stood any chance at all of being successful on appeal.
Okay, and you did the same at the motion for new trial as well?
Yes, ma'am.
Okay. That is all the questions that respondent has right now, Your Honor.
All right, Mr. Leonard, do you have any questions you want to ask the witness?
Due to the newly discovered evidence that I came up with, I have questions, but I won't, no, not right now.
All right, now's the time to ask him as to this witness.
Well, no, sir, no question.
All right, so it's my understanding we're going to continue this, give Mr. Leonard an opportunity to obtain the documents that he mentioned that he needs to obtain to tender, and reschedule this for my May calendar. All right, any objection?
No objections, Your Honor.
All right. That concludes the hearing for today.
Am I excused, Judge?
You are. Thank you, ma'am.
Thank you, sir.
And that leaves us with the Henderson case.
You're good. Congratulations.
And this Russian Watson, is this going to be your case?
It was my understanding that the Henderson case had been continued, though I could be wrong about that. Maybe I'll contact Mr. Lindman and see if he had a different opinion of that.
Okay, let's check with the staff there at Smith and see if Mr. Henderson's available. If it's possible that he's not even been brought out, if it's been continued.
Yeah, I had also had that. I was also under the impression that had been continued, the Henderson case.
Okay, on what? Yeah, we haven't been notified of any continuance. I'm not saying it can't be. This is new to us. What was the basis for the motion for continuance?
One moment, Your Honor. Could Your Honor give us about 5 minutes just to confer on this?
Sure.
Thank you.
I didn't get anything.
Yeah, no, I have it.
Is your camera and my off before I said
Hello, we're back. Your Honor, so it was our understanding that there was a motion to continue that had been filed, and it was due to the unavailability of a witness who was scheduled to appear this morning in court in Emmanuel County. We hadn't received anything back on whether that had been granted or not. I don't know. Again, it was understanding that it had been filed, but if it's not, we have the motion with us.
Okay, all right. And again, I think this apparently is the first time that we're learning of the motion. So who is the witness that you had subpoenaed that may be in court in Emmanuel County?
His name is Mr.
Toby Carr?
Karrh.
You may want to restate that for the benefit of the court reporter. You were cutting out on us pretty bad in that transmission.
So the witness is Toby Carrh, Tobekarrh.
What's up with the?
I don't know what's up with the technology here. But, try that one more time.
Sorry, the witness, I apologize, Your Honor. The witness was Toby Carrh, Tobekarrh, and he was apparently scheduled to appear in Emmanuel County this morning for another hearing, and that was the purpose of the motion to continue.
Okay. All right, Mr. Henderson, do you understand that the respondent is asking to reschedule this for my May calendar due to inavailability or unavailability of a witness? Do you have any objection to continuing the hearing?
No, sir.
All right, so we'll schedule a May calendar.
Yes, sir.
All right, who's the hearing?
That's it. He said reschedule. Exactly.
All right. I think that completes all of the cases. Thanks everyone for your patience. Stay safe.
Yep, absolutely.
All right.
We'll go ahead
Have a
and
great day,
get this.
Judge Stewart.
Very much, Your Honor.
Thank you. Thank you.
Thank you.
Thank you.
Thank you.